Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, I am going to touch a topic of bail. We all know that bail is the personal discretion of the judge. Recently, Honorable Supreme Court of India held that the constitutional courts, that is High Court or Supreme Court, cannot, please remember, the constitutional courts cannot direct the trial court to write the bail orders in a particular format or in a particular way. This is reiterated by Honorable Supreme Court, Honorable Justice Abhay Srinivas Vokha and Augustine George Marcy in the case of Ayub Khan versus State of Rajasthan, SLP number 10,587 by 2023, dated 17/12/2024. Please remember, in this case, Honorable Supreme Court bench made pertinent observation that Rajasthan High Court cannot direct the trial court to draft the bail order actually as per the tabular chart relating to the antecedents of the applicant or the accused person. Here, please read Article 235 of the Constitution of India. Definitely, the Constitutional Court, that is High Court, has got jurisdiction, administrative jurisdiction over the subordinate courts, or which normally in my previous videos also I told you we cannot call them as subordinate judges, trial courts. They can give directions to the trial courts, but they should not give directions like this. You must make a chart out. What are they? So in generally, while considering a bail application, 4 points are 100% necessary, which I have made in my previous videos also. Gravity of the offense, nature of the offense, whether there is any tendency on the part of accused to commit once again the offense, or whether there is any threat to the witnesses. Like that, they have to discuss and ultimately they have to give the order. Whether they grant it or not, it is their discretion. Right, what happened? Better to know. Here, please remember, the trial court decided the bail petition of an accused charged with 307 of the Indian Penal Code and also section 25-27 of the Arms Act. On 20/12/2022, the trial court rejected the bail application. But the trial court did not mention the real previous antecedents of the accused person. That means whether he is previously involved in any similar offenses, whether any cases are pending against him. So all these things were not at all mentioned in the bail order or in the tabular chart form, but simply he rejected the bail application. So this was found fault with by the Honorable High Court of Rajasthan, because in the case of Jugal Kishore versus State of Rajasthan 2020, Rajasthan High Court directed the trial courts to mention the antecedents of the applicant or the so-called accused persons. Right? Similarly, in the case of Gagandeep alias Goldie versus State of Rajasthan 2021, similar directions were given, but Honorable Supreme Court dismissed the same. Right, here, since the antecedents were not written, it was taken as judicial indiscipline. A charge memo was given to the trial court judge, that is Section Judge Ayub Khan. Right. So the charge memo was given and he replied stating that by oversight I could not write the antecedents of so and so. And there is nowhere it is mentioned that it should be written in the particular performer like that. Actually, in his reply, he irritated the bench, irritated the High Court. అందుకనే మీకు చెప్తుంటాను, the language and tenor should be proper. మనం మాట్లాడే లోపల ఎంత బాధ ఉన్నా సరే బయట చెప్పేది, the language should be very, very proper. If you use the impolite language, definitely it will be taken to task. Here what happened is High Court did not accept his so-called explanation, and they said that he has lost the track and he wanted to defend himself in some other way, like that. For without giving the complete details of the antecedents of the accused person, the trial court should not have rejected his application. Therefore, they granted bail. The High Court granted bail. Right? That's one part. The second part is action against the judge. They say that it is judicial indiscipline. He should not have done like that. So then now the remarks against him, now they are casting on his seniority and also on his posting. Therefore, he approached the Honorable Supreme Court of India. Supreme Court of India stated that we cannot, High Court or Supreme Court cannot direct any magistrate, any judge to write the bail order in a particular form. It is highly unconstitutional. So the adverse remarks passed by the High Court, definitely they are expunged, because High Court cannot direct like this. It is totally unwarranted, illegal. Therefore, it is not disobedience by the Ayub Khan. So therefore, it is not indiscipline. The charges of indiscipline were set aside by the Honorable Supreme Court of India. Luckily, the trial judge is lucky enough, he will get his promotion. Okay. So with this, I am concluding here. Thank you very much.